Plaintiffs' lawyers are evolving in the claims that they make. Here are the important changes that website owners need to be aware of. First, more plaintiffs' lawyers are hiring accessibility experts. And I can tell this by the way the claim is written and also what accessibility claims are being made. So we're seeing more specific and more detailed claims. And this is because plaintiffs' lawyers have accessibility experts helping to inform their claims. Also, we are seeing less boilerplate claims. So whereas in years past, it was quite common for there to be templated complaints filed in court with the same accessibility issues, regardless of the website, now that is less so the case. Another change is that plaintiffs' lawyers are relying less upon scans. So in past years, it was common for plaintiffs' lawyers to really rely upon scan results to determine whether or not to initiate litigation. Now that is less so the case. Of course, it's always been best to make sure you have zero accessibility issues returned on the most popular scans, but now that is not enough. Again, we go back to the expertise and plaintiffs' lawyers looking for more issues. It's important to remember that automated scans are limited. They only flag about 25% of accessibility issues under WCAG 2.1 AA, and there may even be false negatives. So you can't rely upon scan results. This has always been the case, but now plaintiffs' lawyers are less relying upon scans, whereas before they were primarily relying upon scans. We're now seeing issues beyond WCAG 2.0 AA. So we're now seeing issues found in 2.1. So 2.1 was released in 2018. So you really wanted to work towards the conformance with 2.1 since that time. But for many years, plaintiffs' lawyers were only making accessibility issues, were only claiming accessibility issues that were found under 2.0. And now we're seeing those evolve into where there are more claims for 2.1 issues. And then the last note I want to make is that accessibility statements are now being named in complaints. So if there's a lack of an accessibility statement or the accessibility statement is difficult to find, now that is now being named in complaints. So these are some important changes that you need to be mindful of, because where you might have advice that is telling you old ways that were once effective or were practically helpful, now that is less so the case. And so I highly recommend my ADA compliance course, because in this course I talk about the accessibility issues that are frequently claimed in litigation. There are a core of 15 accessibility issues that are commonly claimed over and over again by plaintiffs' law firms. And so if you focus in on these issues, that is going to significantly reduce your risk of litigation. I also talk about best practices for ADA compliance. And so this course really just tells you exactly what you need to know to be current and make sure to prevent litigation, and then continue on into full WCAG conformance. But the course will tell you how to strategically approach accessibility, what accessibility issues to prioritize, and how to find and fix those most commonly claimed accessibility issues. So I will link to the course below. The big takeaway from this video is that plaintiffs' lawyers are evolving in the claims that they make.